Members, the House and Committee on the Family Court Proceedings Reform Bill is resumed. Before the dinner break, we were debating Part 3.
Yes, Mr Chairman.
Honourable Phil Goff.
Mr Chairman, Part 3 of the bill is the amendment to the Family Courts Act 1980, and that becomes the Family Disputes Resolution Methods Act, or some such thing. Could I, just before I start on Part 3 of the bill, acknowledge the valedictory speech, Mr Chairman, from the Honourable Leanne Dalzell, which I thought was a very fine speech, and our loss will be Christchurch gain if she is successful in the bid for the mayoralty. But I thought it was a very fine speech, and we will miss her expertise, particularly in the area that we're talking about now, which is the area of the law. I want to, coming back to Part 3 of the bill, Mr Chairman, pick up some of the comments that the Minister has made. The Minister boasted, because she has 20 years as a practising lawyer, I think she was comparing herself to my colleague, the Labor spokesperson on justice. I wonder if she'd compare herself to the people that her predecessor, the Honourable Simon Power, put on the expert reference group. Because when I look at the people that have made submissions on this bill and are particularly opposed, Mr Chairman, to this section of the bill, people like Professor Fred Seymour and Dr Suzanne Blackwell. They've both been clinical psychologists for over 30 years dealing with family court matters. You had Anthony Mann, again a barrister in family law, an expert in the area, 30 years experience. Alan Cook, another barrister working in South Auckland, 30 years. Sharon Otenay, a family law barrister, 17 years experience in the family court. And why I raise that, Mr Chairman, is because 4 of those 5 people were appointed by Simon Power on the basis of their expertise in the law and in family law and on family court matters. And when you appoint an expert reference group, you expect the Minister to listen to what that expert group says. Well, Minister, you have not listened, but listen now, because this is what that group says in the submissions on this bill. They said the proposed reforms are not based on empirical evidence. Not based on empirical evidence. I would like the Minister to take the next call and point to the empirical evidence on which this bill is based. They said this bill is contrary to extensive existing evidence of best outcomes for families and children. Let me say that again to you, Minister. It's contrary to extensive existing evidence of best outcomes for families and children. I would really like this Minister to take the call and explain why she is imposing a piece of legislation on this House that the experts in the area acknowledged, because they were appointed by her predecessor, are saying are not based on facts, are not based on evidence, and they say worse than that again. It says this will create a 2-tiered family justice system, where the more vulnerable members of society will have limited access to assist them in the resolution of family disputes. So it's not based on fact, it's not based on evidence, and it's going to create an unfair justice system when it comes to resolving disputes that have a huge impact on the lives of the children who are tied into it through no fault of their own. It also says that it's entirely foreseeable that the inequalities arising from gender, socio-economic status and ethnicity will become entrenched. I thought the idea of the justice system was that everybody was equal under the law, and it didn't matter whether you were rich or you were poor, you had the same access to the services of justice and you could expect the same outcomes. And this, your own expert reference group, Minister, is saying exactly the opposite will be the case. Now, I also heard the Minister in her address, Mr Chairman, talk about this being about children. Minister, your own regulatory impact statement denies that this is about children, because that regulatory impact statement, let me recall this for you too, produced by your department, says, given the overall, this is the introductory paragraph, given the overall fiscal situation, urgent steps must be taken to lower the cost of the current justice system. That is what, Mr Chairman,
Honourable Phil Goff.
that is what this bill is about. It's about lowering the fiscal costs, regardless of the social and justice costs that imposes on the children and the families that may be denied the services of this system. And this is what the expert reference group says. It backs up what the regulatory impact statement says. It says the overriding fiscal imperative is evident throughout the bill. Such savings, it goes on to say, cannot be to an extent where the fundamental purpose of the family court is severely compromised. So, Minister, I would like to hear from you as to why these people, with much more experience in a section of the law that you've only touched upon, why they are so fundamentally critical of every basic premise in this bill. And what worries me most of all is that this new family dispute resolution service that will be compulsory for everybody is going to be at a cost to the families of $900. $897, I'm sorry, I'm exaggerating. $897. And I want you to tell us, Minister, how a family on a lowish income, but not so pathetically low that they're eligible for legal aid, is going to afford that cost when they are already going through the financial stress of a marital breakup, where they're now living probably in 2 homes and having to spread that across the income that previously paid for 1 home, because that is going to produce financial hardship. Not for people on the minister's salary, she could manage it very readily. Maybe for the people at the very bottom, you know, under if you're with 1 child, under $32,000, you won't have to pay. But people who are the normal, average family battlers that will be on low to middle incomes that will be struggling with the cost. And what worries me most of all, Minister, is that your own regulatory impact statement says after they've been through this process, 5/6 of them will then have to go to the family court anyway. So they'll have to meet the cost of this service at $900, and then they'll have to pay the cost, minus the legal aid that you've taken away from so many of them, they'll have to pay that cost to go to the family court as well. So they are being hit twice. Now, the minister's other point was, most people can just sort this out for themselves. Well, you know, it's true that for a lot of people there will be out-of-court resolution. There is now. Minister, you must know that right now, under Section 9 of the Family Proceedings Act, 85% of the parties reach a direct agreement through counselling under Section 9. The people who can sort their problems out are sorting their problems out now without the extra cost that you're imposing on them. But the other 15% are the 15% where the problems are deeply entrenched. And what the experts say on this is that your proposal will make the situation worse, will make it harder for those families. They won't be represented before the Family Dispute Resolution Service, and they won't be represented in the family court when they get there either. So if you've got an unequal relationship between the 2 partners, that will be exaggerated because the partner that is not equal in strength and resources to the other partner will be at a huge disadvantage. What the expert reference group says here, Minister, you haven't read it obviously, so I'll repeat it to you. This fails to recognise that out-of-court resolution already occurs for the vast number of parents who separate, whether by direct agreement between the parties or with the assistance of Section 9 counselling. Those cases don't go to the family court. But they say the availability of affordable and accessible pre-court dispute resolution process with Section 9 counselling already provides the very tools to parents which are claimed to result from your reforms. They have the mechanism now, if the matter can be sorted out, to do so without the cost being imposed on the parties, because part of the role of the legal system is to provide justice, whether it's an employment law, the judicial law, the family law, or the civil cases. That's what the family cases. Don't let the Attorney General, if he's so smart, take a call and explain why these people, who know far more than either the Attorney General or the Minister of Justice, are wrong when they say this legislation is fundamentally bad.
Chris Farfoy.
Thank you very much.